Hi, this is Irina Shea, and this is part of our Wealth and Wisdom video series. Today, we're going to talk about can I name co-executors of my will? So I'm going to share my screen with some thoughts on that. Okay. Um, so short answer is yes. Question though, but should you? Okay. First of all, let's talk about what an executor's function is. And we have a whole nother video on selecting your executors. But basically, if you die, or when you die, I should say, when you die, the executor is tasked with administering your estate. So, what is that? Selling your house, collecting bank and brokerage, following your terms of your last will and testament or revocable living trust. There is a parallel function of a death trustee, similar to an executor. But they're the ones who, for about a year, are going to be cleaning everything up. If you are under 15 million per person and you live in New Jersey, there's no more state tax filings. So when people used to say, oh my God, I was an executor for my family member's estate, it was a disaster. A lot of it was because we had to file estate tax returns, get appraisals. This was all pre 2018. And so it's simpler now than it has been ever in the past. I would say the biggest job for the executor is clean out of stuff in the house and selling the house. This is where things can get really overwhelming. And there are entire industries now about removing stuff and selling stuff and estate sales and tag sales. And of course, realtors staging, listing, and selling the property. But just going through the seller disclosure form that's, could be 20 pages for selling a house of a house that you don't even know. It's not your house, it's your parents' house. Do they have an underground oil tank? I don't know. I mean, these are sort of heavy jobs. So typically, executors are spouse, then children. So it's often children jointly. So let's just say you have you're middle-aged, you're naming your spouse first, and then your three adult children who are in their 30s. Okay. So it might be A, B, C. What you can do is name them jointly so that they can job share this big job and know that any executor may renounce or resign at any time. We put that into our documents, and in Bergen County, New Jersey, at least, there's a simple renunciation form that if at the time of your death, your spouse isn't up to it because they're elderly like you, or child B is living in, I don't know, New Zealand, halfway around the world, child B can renounce, or elder spouse can renounce, and then child A and C will serve. So what you're doing is nominating an ideal lineup of executors. That's what you're doing. And that includes naming co-executors. Okay, having said that, it may be better if, say, child A is a local accountant, attorney, financial person, or whatnot, and B and C are living very far away, or they are not at all in any sort of field that they like doing this kind of thing. Maybe instead of naming co-executors, you go sequential, right? It could be sequential, spouse, then A, then B, then C. That might make more sense in your case. It's very hard to know until we have these discussions. So in our office, we create what are called whiteboards. They're a blueprint for the estate plan, where you may have tentatively discussed and decided who should be your executors. And we look at that lineup and we just stress test it by asking a few questions to see, does this make sense? Okay. So, these are the sort of things we talk about in our office, in our consultations. So if you would like to learn more, you can go to our website at irinashea.com, click the Get Started tab, and there is no charge for our initial consultations. Thanks.